have some special clauses in here for like I've done some like random deals where it's like different terms in here. So I have that in here. Like I have this, for example, we'll just cover this real quick while we're here. Um, this is in the zero dash pre-contract holder. So in this case, we have an arrangement with the seller. He's a partner in the LLC. He gets paid 100% of the cash flow every month of true cash flow. I don't, it doesn't bother me because it's paying down the principal note. It's not like he's getting all the profit, right? It's paying down his principal. He is getting all the profit, but it's paying down his principal, 0% interest. So we have a 0% interest on that one. So like every month as it's generating positive cash flow, like we're accelerating debt pay down. So it's, I mean, it's good. But in this example, we have a minimum requirement in the bank balance. Hey, if we dip below $7,000, we're not paying you because we need to build up the reserves, right? And that's per property. So we have 5 properties total in that. So you can do the math. Like that's our minimum. So if we dip below that, he's not getting any extra payments because we need to make sure we have adequate reserves at all times. If that makes sense. Um,
If, this is if the sellers know, right?
Yes. Well, this was very specific to a deal of saying he's getting excess cash flow. Just because the seller's on the note doesn't mean that he's going to get excess cash flow. This was kind of like a one-off type of deal. Um, we also put this in the operating agreement to acknowledge that we owe the seller financing, and that's going to be, you wouldn't want to send that to the lender, but by the way. Um, unless you've had that conversation and kind of like cleared all that on the front end. So we talk about the existing loans. Here's a non-performance. So if for some reason we don't perform, we assign the seller, 51% controlling interest in the company, and he takes over until, it's rectified or whatever. Um, this was another one, no distribution will be made to any other members until that loan is repaid. So I threw in terms in here that were different from what I normally do. Again, this like all these special terms came from one contract. And so like he retains 17 and a half ownership until the loan is paid off, and then it drops off at 5%, or sorry, drops off to 12.5%. And you can see how I kind of structured all that. Also have in their agreement where I am the property manager. That's something you should address if you're going to be operating the property. Like for me, I need to, I have costs, right? Like I need to, it's not like I'm making crazy money. Like 5% is not a lot. I need to have something in there so I'm not just like, I'm not getting any cash flow, but I'm going to have expense. So like I just need something to pay the bills, right?
So
Question.
this is not something that you use for this property, right?
No, this is
Okay.
just like this document is just kind of like special clauses. If something weird came up in your deal, you can look at this and see if I have something in here for that. If that
But
makes sense.
I just didn't get it, and I wanted to clarify. Is this something that you would do on each transaction, or is this something that you would do only if you're entering the like if your seller is on the LLC with you?
Probably this is more geared to seller entering the LLC,
Okay.
but even if the seller's entering the LLC, these are kind of special one-off types of deals. So like what I envision this document is over time, any special one-off thing that comes up, I'll kind of throw that in there. That way it's just like, oh, I got this situation and maybe this document has something to kind of handle that. Obviously, you probably want to consult with an attorney, but a lot of attorneys won't even know how to handle this anyways.
Did you don't send this to them?
No. In this example, we did this after closing, where we uh, put the seller in the LLC. It depends how you structure it. I didn't have the conversation with the lender on the front end. Oh, did she not have the mic? Um, she asked she asked if I sent this to the lender, and my answer was no. Should you have? Probably yes. I was pretty far deep into the process where we closed on the loan. And then after closing, we brought the seller in to retain, you know, his security. That's how we secure the seller, but we secure the seller after closing. You definitely could find lenders that are okay with that type of structure, though. You just have to find them. Does that make sense?
So for the instances where people are securing the seller by putting them in their LLC, this is something that you would do beforehand and you would present to the seller, to the lender beforehand.
Again, this whole like weekend, I've made every mistake you can possibly make in figuring out like how to do things correctly, right? Um, you're definitely taking on some risk if you did what I did in this situation where you did it after closing, but you would want, if you were going to do it letter by the law, right, by the book, you would do it up front, and you would find a lender that is okay with having your seller partner in there in the LLC. Versus what I did here, I did it afterwards.
Got it. So how does that affect you if you do it afterwards? I mean, yes, okay, it's not by the book, but
Yeah, I
what
mean,
could
good
be
question.
potential implications of that?
The operating agreement is never posted anywhere. It's not a recorded
Right.
document. Like no one would ever find, the only way this would find out is if the seller picked up the phone and called a lender and like sent him the document. And for that seller to do that, he'd be cutting off his own foot, but things would have had to gone very south between us for us to do that. But I would assign my interest over to the seller. I don't know why he would want to do that because I would just assign, maybe let's say a buyer refused to do that. That might be a situation where he calls up the lender and says, hey, we did, you know, I don't know. Right? I mean, logically, it doesn't make sense how anyone would know that.
Got it. But this is not your preferred way of doing this, just to be clear. Putting the seller on their LLC.
I'm not a biggest fan of it just because it's just a different level of relationship when they're a
Right.
partner. But if you're concerned about second positions, it is a better way of doing it to avoid any of that. And then you don't have to worry about sourcing a lender with second positions because there is no second position.
Right. Okay.
That's where what Duran, probably saying his name wrong, Doran. No, but anyways, that's what Doran was saying the other day. As far as instead of like in place of a silent second, you have the UCC1 filing, which I think is a
Correct.
pretty
Yep.
valid, like secondary option or first option, depending on how you look at it.
There was a clause in that document on top where it was like a default clause, and it stated that the that you would relinquish your rights to the LLC. How is that? What would the seller have to do if, let's say, not stating you, but let's say another buyer would say, you know what, I'm not gonna give you, I'm not gonna assign my rights to you in the LLC. Do they have to then litigate as a mediation? Like, how do you explain that to a seller if they say, well, what if you just don't want to, if you default and you don't want to assign the rights to me to the
Then you
LLC?
have to sue you. I mean, that
Mhm.
would have to be what happens, and then that would drag out for a while. I mean, people are people, you know, I can't understand how someone would, you know, default, you know, whatever circumstances happen and they wouldn't step up and do the right thing. But I've seen many times where people don't do that. So it is a very valid question. If they refuse, so the seller would have to sue.
Mm-hmm. And then also
And
when
they
it,
would win, for sure.
yeah. Or you could put a clause in there instead of like suing, you can do like mediation, right? Where you don't have to really go to court.
I mean, that's probably going to end up happening anyways. If you get
Yeah.
into a situation, I mean, you can negotiate. If you want to put it in there, you can, for sure.
Mm-hmm. And then another,
Still costs a lot of money.
yeah.
I've been in it. It's not fun.
And then another question was when it comes to, what was the other question? Oh, like a UCC filing, when you do that OA, right, after closing, couldn't you upload it to the actual state website and they have it under like the filings? Like
The
amended?
operating agreement?
Yeah.
Oh, I would never do that. I would never do that.
No, I'm just saying, but you
Could
could
you?
though. Yeah.
Yeah,
Yeah.
you
yeah.
could, but
Yeah.
I would never do that.
Okay.
Yeah.
I'm just thinking like if I have like a very savvy seller with an attorney looking over documents, saying, okay, well, I want to see this recorded on the state's website. Like you can go to Illinois, right? Like if you're amending your the membership or anything like that, it's under filing, so you can actually click on it, you can see it.
Let me correct that, I guess, my statement. I would never, definitely would never pitch that or volunteer that, but if that's what it needed to be done, I would just make sure, my personal information wasn't on that operating agreement, which it kind of has to be. Well, in essence, if you had a holding company, right, or an LLC that owned the interest, like they wouldn't be able to find me. I'm not worried about not performing. So if that's what it really took to get the deal done and I really wanted it, then I would probably do it, but I would not like even remotely pitch that, you know what I mean? But if they suggested it and that was the last thing to get the deal under contract and close, I wouldn't necessarily be opposed to it just because I know like I have nothing to be concerned with. And if for something unforeseen happened to me, the right thing to do would be to perform on whatever that agreement is anyway. So like if you had a buyer that was like immediately refusing, I'm questioning their integrity at that point. It's like, why are you immediately refusing? This hasn't even happened. Like this is not even a scenario. But if you're already fighting the fact that you don't want to perform on what your obligation is to just do the right thing, I have some serious questions, right? That for me. I wouldn't even want to do business with someone if they're fighting, if they're like fighting that kind of thing. That's a huge red flag to me. As a seller, I would cancel the contract. I'd be like, I'm not doing business with you. If you're fighting me on like you don't want to do this in a default, like that's not good.
So another question that I have is, let's say the seller is on the LLC, but your capital partner should also be on the LLC, right? Would they be both on there?
Yeah, yeah,
Okay.
yeah.
Any particular
Which I have that.
percentages?
I have that
Okay.
exact scenario. The seller finance deal, Monique's on the LLC, the seller's on the LLC. I'm on it. Yeah. No, it's whatever you want it to be, whatever you negotiate, you know. I think it's more just having them in the deal is good. The other reason why I wanted, to have Monique in there, I don't even know what she has. I think it's like 5%, something like that. It's going to look really weird when you have this partnership. If you think about, this is a good question because if you think about including the seller in the LLC, different level of commitment and transparency, and anytime you make a change to the operating agreement, they need to be involved, right? So if your capital partner is exiting, you almost would have to have them exit first before you bring the seller in, if that makes sense. Because if you brought the seller in, they're on the operating agreement. Any changes you make to the operating agreement, he needs to sign, right? Um, then you're going to have this weird, awkward conversation of like, we just closed. Why is this person exiting? You're going to have that conversation with the seller.
But if it needs to be provided to the lender and you need to show that you have a capital partner, but also your agreement with the seller is to have them on the operating agreement and the LLC, then wouldn't they need to both be on the same operating agreement that you're providing to that lender initially?
Yeah, that's a good point. Like, yeah, at that point, if you have someone exit, because in our scenario, when I was thinking through that, we didn't have to worry about that because like, the capital partner wasn't exiting, they're staying in it. But like if you think, yeah, in that exact scenario to qualify funds or whatever, we didn't really need the funds to qualify. It was just more of like a funding mechanism. But in that scenario, they're on the operating agreement and then you close and then you add the seller, the capital partner has to exit. They're going to be like, what's going on? Like, why is this person exiting? Like, I'm very confused.
But you would have added them on before you provide that document to the lender.
If I was adding the seller on the operating agreement with the lender, but the way you could do it is like the seller's not seeing the operating agreement when you're getting the loan. So they don't even know the capital partners involved. You could, after closing, they exit the partnership based upon the terms, and then you bring the seller. The seller doesn't even know that the capital partner was technically in there to begin with if you did it that way.
But I thought the lender had to know that the seller was on the LLC.
Had to or
Good.
should is two different things. Because when I closed, they didn't know.
Right, which you
They
said if you were
should.
doing it
Yes,
by
correct.
right.
They should know.
So that would
Yeah.
mean that they would both be on the LLC when you on the operating agreement when you provided it to the lender.
Yeah, so that I mean that those are things that you would need to talk through with your client to make sure they're aware you're asking the right questions on like, hey, just so you know. And that's where the experience comes in as far as being able to provide that counsel to clients, right? Well, not
Right.
not counsel, but you know what
Right.
I mean.
Guidance.
Guidance, yeah, guidance, right word, legally right term, to be able to help them navigate those landmines before they
Right.
happen. So when people do a Morby method with me, they're like, wow, this was so easy. They don't even know I like navigated, you know, I deterred them away from 50 landmines, right? Like
Right.
that didn't even happen. They were like, this is so smooth, but they go and do it on their own, and they're making posts on Facebook like, help, I can't, the buyer can't perform, we can't get the title company, and I'm just like, well, that's, and those are the people that were, you know, too cheap to like pay for advice and all that stuff, right?
Right. So then when you're taking them off though, couldn't it just be as simple like, hey, I just need you to sign this operating agreement again? And I mean, don't, in my experience, 90% of the people are not even reading the documents that they're signing. Like, is it really a question that they bring up or?
If you have this weird timing issue, the way to fix that is you're just transparent with the seller. You know, if you told them in the beginning, hey, I have this capital partner. If you know that you're going to start pitching this seller LLC thing, I have this capital partner. They're going to come in and fund it, and then after close, they're you know they're basically coming out, right? And if they're on the same page, like it doesn't matter at that point. You're you know the worry is that you have this weird conversation that the person's in, they think you're the
Right.
partner,
So
and
you
then
should
they're
just
gone.
manage expectations up front.
Yes,
Okay.
exactly. Depending on how you want to structure it, you pivot in different ways, which is why it's like there's 50 different ways you can go with the Morby method, and it's impossible to capture all of them. And that's where experience comes in. You just have to be prepared to pivot. And, you know, I've seen almost every scenario um, from a buyer perspective. I've never been on your guys' side. So I'm sure you have different things that come up on your end, but that's just part of it, right?
Common thing is with these transactions, the most success is going to come from being transparent. Like,
Yes.
honestly, the transparency is the way to go in these.
The more transparent you are, the easier you're going to be able to move and pivot. That's why it's really important to build that rapport with the seller on the front end to make sure that you're on the same page with each other and you're not, you know, at opposite ends where you're kind of hiding stuff.
If they're a savvy seller and they start looking into it, then you have to kind of understand what you need to tell them if they're asking afterwards.
Yep.